The following is a paid presentation by Siniard Law Injury Attorneys, paid for by Siniard Law Injury Attorneys. The Siniard Law Show, answering your legal questions, featuring attorneys Tommy Siniard, Bart Siniard, and your host, Aaron Dacey. This is the Siniard Law Show.
Good evening and welcome to the Siniard Law Show. I'm Aaron Dacey. This show is all about education, and we encourage you to submit your questions by leaving us a voicemail at 844-7000-LAW, or you can email us questions@siniardlaw.com. This evening, we're tackling injuries and the law. We have attorneys Tommy Siniard and Harrison Lane with Siniard Law Firm right here in North Alabama. Welcome. Can't wait to learn from you guys.
I'm so happy to have Harrison here. He's an associate with our firm. We go way back. Harrison graduated from the University of Alabama and then the Mississippi College of Law, and he's in our third year of practice as an associate with Siniard Law, and he's just doing so great.
Wonderful.
Welcome, Harry.
Thank you. Thank you for having me back. I'm glad to be here.
Yeah, we're excited to learn some things. We always do every week. So, gentlemen, let's start off with our legal tip of the week. And this week we're talking about uninsured motorist coverage and why you might not have enough coverage when it comes to injuries.
So, when someone says, I have full coverage, lots of times you don't know what that means. There's really 4 or 5 little policies within the car policy. Collision, you can get your car fixed, whether somebody causes the wreck or you hit a telephone pole. There is liability insurance when you cause damage to another person. There's med pay, and there's towing, and there's uninsured or underinsured motorist coverage. What that means is that if a person hits you with no insurance, and keep in mind 1 out of 5 people you pass on the road have 0, or someone that doesn't have enough insurance for the harm they caused, you can turn back against your own policy, and it stands in the shoes of the wrongdoer. People say, I don't want to do that. I mean, this clown hit me, and now I'm after my own insurance company.
Does your premium go up?
Premium can't go up. You can't be canceled.
Good.
It's not your fault. So that's what you've been paying for since you're 16 years old. So we had a lot of those cases, Harrison. Tell the viewing audience the process of going through first the wrongdoer's liability coverage and then turning to the coverage.
Certainly, and what a lot of people come to find out, unfortunately, is they've been hit by somebody who doesn't have insurance. And what ends up happening is you make a claim with that person, and a lot of people will get the insurance card, put it in their glove compartment, and then never pay it again, right? So immediately it gets canceled after about a month. So what do you do at that point when you get a letter from the other person's insurance company saying, hey, we're not paying you anything, we're not covering anything, this person wasn't insured? Well, you turn to your own insurance for your uninsured, underinsured motorist coverage, and that can, based on your policy, cover you for any injuries that you sustained due to somebody else's negligence. Another big part of all of that, though, is the key word in uninsured motorist is motorist. And if you're in a wreck not caused by another motorist, you better have medical payments coverage, because otherwise you're not going to see a dime from that. If there is not another vehicle or another motorist involved in it, your uninsured motorist coverage isn't going to, it's not going to give you anything.
Right. So what we tell people, most folks don't have enough uninsured, underinsured motorist coverage. And here's the data. 1 out of 5 people don't have any coverage. So I tell people, buy more. It's not expensive to increase your uninsured, underinsured motorist coverage, because what you're going to find in 80% of the wrecks, there's not enough coverage for the harm that you've suffered. And it doesn't cost a lot. And it's something everybody that drives a car should look into.
So do you have like a standard number of what you think a minimum should be?
I think you should have a minimum of $100,000 in underinsured motorist coverage, but that's just...
And then as soon as we say that, what ends up happening is somebody gets injured and they really need $300,000,
right.
$500,000.
Right. But if you only had 25, then, that gap will...
So many times we have cases where the liability is clear, the injury is bad, but there's not enough coverage between the liability coverage of the wrongdoer and the person's uninsured or underinsured motorist coverage to carry the freight. They end up getting shorted as to, if there was plenty of coverage, it might be a $500,000 case and they get stuck with $75,000. So it's very important to look at your own coverage. So there's people driving around that have a $900,000 house and $700,000 in a 401k and $20,000 in CDs that have this much liability coverage. If you commit negligence and hurt somebody, once they exhaust that limit, they may be looking at your assets. My daddy used to say, it's one thing to get money in the front door, but you better lock the back door. It's pretty good advice. Mm-hmm. So
that's easy to remember.
as you get older and you gain more assets, including the equity in your home, you better lock the back door and get more liability coverage in case you inadvertently have a wreck and hurt somebody.
Some great advice. Now let's get to a viewer question, guys. They say, I was walking through the grocery store when I stepped in some water and fell. The manager took my information and said that I should hear from someone. That was over 2 months ago. So what options do I have?
Sounds like you need an attorney.
Yeah. The first step is, before the evidence gets away, you need to lock down an attorney, because this evidence, I tell folks that work with me, evidence is like water in the sun. It gets splashed, it gets evaporated, it gets moved. In a criminal case, they put this yellow tape around a crime scene to preserve and protect the evidence. That doesn't happen in a civil case. So let's go to the grocery store situation. Just because you fell in a grocery store and got hurt doesn't mean you're entitled to recover. The burden is on the plaintiff, the injured party, to prove by a certain standard of evidence that the hazard in the grocery store was there for such a length of time that it could or should have been removed, noticed and removed. So let's take this instance. Somebody slips on a banana peel in the grocery store and they say, oh, well, this is easy, I want to recover. Well, I need to know who dropped the banana. Was it a store employee or a customer? Mm-hmm. How long's it been there? Was it there a length of time that it should have been noticed and removed?
And is the burden on the injured person to find this information? What if they're so injured they can't answer those questions if they hit their head? Or
that's why I'm saying preserving the evidence. Now, first thing you should do if you fall in a store is report it, right?
Absolutely.
Take it from there.
So, but in essence, like with anything, you have a duty to report it, but also it's going to help preserve that evidence. Most businesses are going to do some kind of incident report, take pictures, whatever that looks like, and you would hope they go ahead and turn it over to their insurance company. With this person's question, sort of the issue is, it sounds like she's not getting any response, even though she was told that she would. And that's not uncommon. A lot of people end up speaking with somebody, an adjuster, with an insurance company, whomever it may be. They never get a call back. They call, they leave voicemails. And it's one of the reasons, as Tommy alluded to, why you would want to get an attorney. One, you want to preserve that evidence, make sure it doesn't dry up in the sun. But also, if you're getting the runaround, there are certain options that an attorney can help you with that you maybe aren't able to do on your own.
A lot of these stores have video cameras, and you need to get a lawyer to file what's called a letter of spoliation. If you say, keep the evidence, hold on to the video, and they destroy it, then there's a presumption that they were at fault. So that's one of the first things we do, is issue a spoliation letter.
Absolutely, and I would highly recommend this lady give us a call. I think it's at least something we could help her get answers to, if
right,
nothing
and
else.
It's one of those things like what you've explained before, that she might not pay anything unless there is a recovery.
Absolutely.
You just have a consult, free consult.
Right.
We appreciate your expertise on this. Now, if you would like monthly legal advice in your email inbox, Siniard Law's got you covered. Sign up for their newsletter. In it, you'll receive free monthly legal tips. Just scan the QR code, or you can sign up at siniardlaw.com. When we return, we'll answer more of your questions about injuries.
I got sandwiched between an 18-wheeler and a truck. During the accident, I lost my left leg. I chose Siniard Law because my granddad knew they had a great reputation. They were very knowledgeable. They were very sweet. We had a connection. They pretty much treated us like family. I would definitely recommend Siniard Law because they are caring and they will help you get what you deserve. If you've been injured, call Siniard Law.
A feature of the Siniard Law Show is education about folks who are doing amazing things in our community. Let's check in with Tommy Siniard now. He's got probate judge Frank Barger to talk about the probate court.
Thanks, Aaron. It's my great pleasure to introduce probate judge Frank Barger. He's a probate judge of Madison County. Judge Barger, welcome to the Siniard Law Show.
Thank you, Tommy. It's good to be here.
Tell us something about what is a probate judge and what do you do?
Well, I've had friends say that we're a community minister to an extent. The community, our constituents, our residents have access to the probate court, generally unlike the circuit or district court. So we provide a lot of direct service. We're the official record keeper for the county. So everyone does business with our court. Every real estate transaction, certain business documents are recorded with us. But we handle, as far as judicial duties are concerned, we oversee conservatorship and guardianship work, end-of-life issues, as it relates to probating someone's estate. We also serve as the chief elections official in the county. And some of the things that are most important to me, we serve as the judicial officer that oversees the involuntary mental health commitment process, and we also oversee the great majority of adoptions in each county.
Probating of a will. There are sometimes will contests.
Yes,
Talk
sir.
to us about that.
They generally will revolve or be initiated by someone who's unhappy about how they've been treated by the individual who has passed. So usually we can make it through that with relative ease because you come quickly to understand that it's a dynamics issue. I've had other members of your team, and certainly the legal community at large in front of me, and we get rid of those dynamics right away. I can't fix what led the decedent to make the decision they made. But if a will meets statutory requirements of being self-proving, meaning that we have an original copy, it was witnessed by two individuals, and the signature of the testator and the two witnesses are notarized, I really don't have any other choice under the law but to admit that. If it's contested, should they choose for me to hear that in the court, we make a determination on, did the person have capacity to sign that document? There'll be testimony provided on that front. Generally, that can be supported. A good estate planning attorney is going to make sure that when they're completing those types of documents for someone that they have capacity. So that's what we're going to hear from first. We don't handle them with the frequency that we used to because I'm trying to be as good as I can and expedite that process by telling them this is what it is. You might be unhappy with how you're treated and you can spend thousands of dollars, but you're going to get what you're going to get, or you might not get anything.
Right.
And so we're very practical in how we approach it.
So talk to our viewing audience about the benefit of a will versus dying without a will. How does your property and assets go without a will?
Sure. Well, if you die intestate without a will, your assets, whatever they may be, are going to be distributed based on an administration and are very specific in statute. And so unless you want state code to dictate how your assets will be distributed, I would certainly encourage everyone to have a last will and testament in place. Example, someone passes, they leave a spouse and children. Typically, the easiest way to look at that is statute is going to require that half of the estate go to the spouse and the remaining half be split among those children. If there is no spouse, the entirety is going to be split evenly among those children. But there are other factors to consider. Are there debts against the estate? Is there real property that has to be dealt with appropriately? The best thing anyone can do, no matter their means, whether they're the average Joe like I am, who have reasonably normal assets, own a primary home, have vehicles, and have some investments, a retirement account, the best thing they can do is have a standard will in place. It certainly makes life much easier for those that you leave behind. And there are also ways to structure assets so things don't have to pass through the court.
Right.
And we see that with great frequency as well. But having those planning documents in place is extremely important.
Let me go quickly to your role with people that are mentally incapacitated, because you do as a probate judge, commitment hearings,
Yes, sir.
involuntary commitments. Talk to us about what you do there.
Well, I'm very proud of the work that we've accomplished with the commitment process. Sadly, folks will come to the court when they have hit rock bottom, when they have alienated their support system, or we see certain situations where it's someone's first mental health break. We see that with young students. Maybe they're in their first semester of college, they're overwhelmed, and something they've experienced causes a break. So it's either that extreme where it's their first time and their support system and they have a great one, don't know how to address it, or it's someone who has been through and the process over and over and have alienated their support. That's going to turn out in one of two ways. During roughly a 7 to 10 day process of being in inpatient care, we're going to determine whether or not they need additional time. If they need additional time to stabilize and for us to formulate a long-term treatment plan, we're going to do that. Typically, if it's a first break, they're going to be in a shorter period of time, and we're not going to ultimately commit them to inpatient treatment, but we're going to provide them support outside of the court through an assisted outpatient treatment program. We also convert all of our inpatient patients to outpatient treatment once their inpatient treatment has concluded. And that's probably, Tommy, the thing that I'm most proud of. We were one of the first counties in the state to do it. We pay for that through passport revenue. My office receives...
So it costs them nothing, the patient.
Right. It does not affect the bottom line of the county's general fund. I learned prior to taking office that my office could serve as an application site for the State Department, and I collect a $35 fee for every passport that we process. Now,
that goes for the mental health.
Correct. Specifically, we use 100% of that. The funny thing is, I could keep that personally. The law would allow me to collect that.
But you don't keep a nickel.
We turn it all over, and through our AOT program, we provide 150 days of support to the person who has been through the commitment process, whether they've been inpatient or we're treating them off the bat on an outpatient order. That allows us to support them through case management, to track their progress, to plug them into resources. And what we have found in our court is that we have reduced recidivism to less than 20%.
Recidivism means doing it over and over
Correct.
and over again.
When I took office, our recidivism was about 56%. And so we're seeing folks less frequently. Ultimately, we are saving taxpayer resources. But the most important thing is we're helping those folks that are fragile, those folks that are broken with their mental health and need that type of support. I'm extremely proud of that.
You do a great job. Thank you for being here, Judge.
Yes, sir. Glad to be here.
It's fascinating, Harrison. I had no idea the probate judge did so much and that he could take the personal money.
Yeah,
but he doesn't do it from the passports. That was interesting.
And Judge Barger doesn't take a dime. I mean, he's just that kind of person. He's a great representative for our amazing county, at least here in Madison County. And, you know, he does a lot for child advocacy over there and is trying to help the community, especially children who are, you know, their parents have died, they have nowhere to go. You know, he's really taking a step forward in making sure that these children are taken care of. So we're proud to be associated with him.
Yeah, and thankful for the Siniard Law Show to put the spotlight on him, that's for sure.
Absolutely.
When the Siniard Law Show returns, we'll answer more of your questions, including a question about a fall at a nursing home and an on-the-job injury.
Our firm, Siniard Law, we represent people who have been injured due to the negligence of somebody else.
I think we separate ourselves by not only our experience, but our community involvement and our dedication to every client.
The people of North Alabama are very important to all of us because this is home.
We are a Huntsville law firm that cares about Huntsville and North Alabama. If you've been injured, call Siniard Law.
Welcome back. We're all about answering viewer questions here on the Siniard Law Show. Let's listen to this voicemail about an injury in a nursing home.
Hey there, my name is Daniel. So my mother fell at her nursing home, I guess it was a few months ago at this point. She ended up breaking her arm and had to have surgery. When we were talking with the nursing home, though, they couldn't tell us what happened. No one seems to know why she fell in the first place. She's always been a little bit clumsy, but I don't really know if that should matter. And I can't get anyone to explain to me what happened. No kind of video, nothing. Like, do we have any options here against the nursing home?
Well, you know, no secret or surprise that you can't get any answers because you're not going to find any nursing home that's going to jump up and say it's our fault. Mm-hmm. And again, the more time that passes, the harder it is to prove whose responsibility the fall is. Now, in nursing homes, there's an intake done, a questionnaire, and it covers every category, what the person's feeding needs are, their watering, their medications, their religion, and what their social activities are. And they develop a care plan for that. And if someone is a fall risk, they're supposed to develop a fall risk plan to prevent falls. So the first question here would be to look at the care plan and see if this person was a fall risk, and did they incorporate the proper modalities to protect the person from falls. The second thing is after there's been a fall, it's supposed to be reported in the records, rarely is, and nobody's
Wait, go back. What do you mean reporting in the records? You're reporting it to administration?
Well, in the medical records, they're supposed to say, found a patient on the floor.
And who's filling that out?
Typically a aide or a nurse.
Okay.
So there might be something a lawyer can glean from the records. But Harrison, we rarely see confessions of, oh, she was a fall risk and it's our fault.
I would say rarely might even be an over-exaggeration.
Right.
I mean, we never do you get any kind of admission within the records as to what you may get that somebody fell, but it never really how it happened. And typically I would say the same thing to this viewer is with your mother, where there's smoke, there's fire. You're gonna come across something that's not within the records and it wasn't reported, and there's probably a good reason why it wasn't reported. Whether nobody was there to help them move and they fell, or they didn't position them properly and they fell. There's a lot of different reasons as to how that comes about, but it's highly unlikely you're gonna find that within the records. And these nursing homes, Tommy, they have a duty to keep up with those data sets that you talk about, those care plans. I mean, do they update them whenever there's an incident, or are they reevaluating as time goes on?
Well, they're required by federal law to update it when there's been a change in circumstance or condition. And what we've seen over time is that people who are in nursing homes their very lives are at risk. We were covering nursing home negligence. You would think it's complicated medical things. Improper medication errors, didn't give them the right medicine or gave them too much medicine. Dehydration, that means not getting water. Feeding, losing too much weight. Preventable falls, these things are all preventable. If daycare was like nursing homes, there'd be a Mother's March on Washington.
And kind of, to our previous point, talking about preserving evidence or it being like water in the sun, when it comes to these nursing home cases, you are dealing with elderly patients, and the studies show that when an elderly person breaks their hip, there's a rapid decline. They're closer to death. And Tommy, what happens though when somebody's injured, but a lawsuit isn't filed? They haven't reached out to an attorney. They then pass away, or the injured person passes away, and now they come to us for help. What's that claim?
So we've got crazy law in Alabama. If you do not file a lawsuit for a person who has been injured before they die, the claim for injury dies with them. So with elderly people who are sick, you find us racing to the courthouse to get a lawsuit filed in time before a person perishes. And if you don't, then you don't have any claims for the medical bills related to that, the pain and suffering, the mental anguish. That's all gone upon death. So then if you're gonna have a case at all, you're gonna have to prove that the injury or the negligence caused death. Well, that's a whole nother hurdle. And so we find ourselves in urgent situations to protect a person's pre-death claims.
So many questions. I still have more, but we've got to move on. Let's get to our next email question. This viewer writes, I injured my shoulder at work while unloading a truck. I ended up having to have 2 surgeries on my shoulder. My doctor sent me back to work. Now workers' comp is offering me $5,000 to settle my case. Here's the question. Should I take that offer?
Almost always no. They're going to lowball you when you don't have a lawyer. Let's go over the comp, what you're entitled to. If you're injured on the job, regardless of fault, under Alabama law in most states, you're entitled to 3 areas of compensation. One, you're entitled to 100% of the medical expenses both now and in the future for that injury. You know, it doesn't count to get your eyes examined or your teeth cleaned, but that goes on forever. 2, you're entitled to 2/3 of your average weekly wage while you're out of work on doctor's orders. So for instance, if you made $900 a week, you get $600. And that goes on as long as the doctor says you can't work. Temporary total disability is what it's called. Then if you suffer a permanent injury that has a permanent impairment, it's a complicated calculation as to what you're entitled to. Not a lot of money to be had in workers' comp, but everybody gets something. So they don't, the employer rarely tells the person about step 3. Oh, you're entitled to a chunk of money because you've got a 5% impairment to the arm or a 10% injury to the body as a whole. And they don't have to. And so people lose out on tens and $20,000, $30,000. This person offering $5,000 for 2 surgeries on his shoulder, I can assure you the case is worth more. And if that's closing the medical, that's closing a benefit that she would have for life. So,
which is why it goes back to your point that you really need to call
initial
an attorney.
Consultation with us and most injury attorneys is 0. The fee for comp is 15%. So it's not like we're running off with a wheelbarrow full of money. So you should consult an attorney that does workers' comp. Not many do anymore because it's not a way a lawyer makes. It's not lucrative. I do it because my daddy worked in a plant for 43 years. And I promised him I'd do them, and I have. And it's something I'm proud of.
Absolutely. And look, this is my employer. We established that from the get-go, and I love him to death. But I think a common misconception for a lot of people with workers' compensation claims is, I've got mental anguish, pain and suffering. What about all of that?
Yeah.
Under Alabama law, workers' compensation is an absolute remedy. And what that means is that there is no claim for mental anguish. There is no claim for pain and suffering. Your only claim is workers' compensation. So you see 2 surgeries, $5,000, you go, wow, he's probably holed up at home for a lot of times, a lot of sleepless nights. Unfortunately, there's no added benefit in terms of pain and suffering and mental anguish. There's a mathematical formula that the Alabama Workers' Compensation Act puts out, and that's essentially the evaluation of your claim. As Tommy alluded to, there are things like closing medicals. We've seen some voluntary resignations even, but that's where it becomes a bit of a tricky situation or a conversation to have with somebody, is that they're not understanding they've been through so much. It's been multiple years. Why is their case only worth $10,000, not $100,000? And it's because of that remedy.
Calculation. Thank you both very much for your education, Harrison and Tommy. We appreciate you taking these viewer questions and educating us about injury law. Next week on the Siniard Law Show, we'll discuss injuries at work and we'll highlight the Semper Fi Veterans Group.
The preceding was a paid presentation by Siniard Law Injury Attorneys, paid for by Siniard Law Injury Attorneys.